Alright, so today we are going to go over fair housing basics, and I'm going to walk you through what fair housing is, what it means, how to comply, different things we can and cannot do, what we can say, what we can't say, so on and so forth. So by the end of the class, you should know a little bit about fair housing history, the protected classes that are federally protected, possible local protected classes, how fair housing can affect you and your job, fair housing and advertising. We'll take a look at the logo real quick, reasonable accommodations versus modifications, if there are any exclusions to fair housing, what can happen if we violate fair housing laws, who's responsible for following them, how we can stay in compliance, and then what's new in the world of fair housing. So, just some basic history. The idea of fair housing originally started with the Civil Rights Movement, and the first law that actually went into effect in regards to housing and protected classes was the Civil Rights Act in 1866, and it prohibited any type of discrimination based on race. While that law did go into effect in 1866, there were absolutely no criminal repercussions for anyone that was violating the act. The only way someone could get back at someone if they felt that they were being discriminated against in fair housing in regards to race was a private solution, such as a suit in civil court. I bet you can imagine exactly how many lawsuits were actually brought up in 1866 in regards to discrimination based on race. And if there were any that was brought up at that time, I imagine that not many went through and ruled in favor of someone actually being discriminated against. It took another 100 years for additional protected classes to be added, and then it actually added a solution for the federal government, which gave HUD the right to pursue discrimination cases. So it took over 100 years for the country to actually give people another basis for pursuing a case if they felt they were being discriminated against. It also added at that time the protected classes of color, religion, and national origin to the already named race protected class. And then 6 years later, in 1974, the act was amended again to include gender, so no one could discriminate against you in housing, whether you're a male or female. And then the last time the federal law was amended was back in 1988, and that amendment included persons with disabilities or handicap, and then also familial status. Does anybody have any questions on the history of fair housing? No. Alright. So as of now, as of today, there are 7 federally protected classes. That's the race, color, religion, national origin, gender, handicap, or familial status. But your state and local government might also add locally protected classes. There aren't any here in Indiana. However, the state that you operate in, whether it's Illinois, Kentucky, Ohio, Michigan, they may have additional protected classes. Even your county or your city government might also add protected classes. Some examples of those are source of income. So you wouldn't be able to discriminate based on someone receiving Section 8, for example. You wouldn't be able to say we do not accept Section 8. Another example of a locally protected classes would be sexual orientation, gender identity, marital status, ancestry, or age. Those are all examples, and it's not an all-inclusive list. There are others. Make sure you check with your local apartment association or your eviction attorney to find out if there are any protected classes in the area that you operate out of, if you are unaware. So fair housing with sexual orientation and gender identity. While the Federal Fair Housing Act does not specifically include those 2 protected classes, an individual may still have the right under FHA if they feel they've been discriminated against to pursue a case. For example, a gay man is evicted because his landlord believes he may infect other residents with HIV. This can be perceived to be discrimination against someone with a disability, and that would be covered under FHA. Another example would be a property manager refuses to rent to someone who is transgender. If it can be proved that the denial is due to the prospective tenant's nonconformity with gender stereotypes, it may be discrimination based on sex and gender. Another example would be an underwriter for an FHA loan is reviewing an application for two males. He assumes they're gay and denies the application despite their fantastic credit. This might violate HUD regulations, which prohibit FHA-insured lenders from taking perceived sexual orientation into consideration when verifying income. So, even though there might not be specifically labeled as protected classes, if someone feels that they are being discriminated against for one of those other reasons, there may be ways for them to receive some sort of action on their behalf if they feel they're being discriminated against. Does anybody have any questions so far? No. Alright. So how fair housing can affect you and your job? Fair housing affects everyone in the real estate industry. Real estate salespeople, brokers, property management personnel, which would be us, and even those in the real estate finance industry. It can also affect our owners. Fair housing applies mainly to the marketing of housing and the showing and selling of housing. However, foresight prohibits discrimination in any aspect of our housing providing service to our residents. So, for example, maintenance request management, handling resident complaints, evictions, move-out process, so on and so forth. We need to treat everyone the same and give everyone the same great level of customer service that we would give anyone else. Steering. Steering is a form of discrimination that involves directing groups of people, often minorities, to certain areas of a city. In multifamily, this can be construed as directing certain races, religions, or other protected classes to specific buildings, floors, or areas of a property. To avoid steering, simply give your prospective tenants the option to see all available apartments that meet their criteria, obviously. If somebody tells you that they want a first floor, one-bedroom apartment towards the front of the property, and that's what they tell you, not what you're perceiving in your head, but those are their things that they're looking for, and you only have one that meets the criteria, so obviously you're going to show them that one. But if you have several, make sure to give them the option to see all of them. And maybe once they see one or two, they might settle on one that seems to be the perfect fit for them. But you're giving them the option to see everything that meets the criteria. You also want to make sure that when you are talking about your property in the community, that you avoid making statements about demographics. For example, if someone asks you what kind of people live here, number one, that might set you on alert because that is a number one question that our secret shoppers like to ask when they're going on tours. So ding, 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 might be a secret shopper if they ask that question. Number two, your response to that question should always be, we rent to anyone who meets our qualifying criteria. You don't want to say we have a lot of families, we have a lot of older people, we have a lot of Hispanics. You want to make sure that you are saying we rent to anyone who meets qualifying criteria, because we do. Screening application criteria. So having written guidelines for screening and applications and making sure that you're following those guidelines can avoid discrimination as a result of the screening process. The guidelines need to include occupancy standards, availability, holding policies, employment history, income guidelines, credit standards, etc. But we cannot ask questions regarding disabilities, number of children, so on and so forth. We can ask how many people are occupying the apartment, because that's a question to make sure that they're going to meet state, local, company occupancy standards. But we don't want to specifically say how many kids are going to be living in the apartment. We can also ask questions regarding prior evictions, landlord-tenant history, and bankruptcy, because those are important in regards to credit and credit standards and isn't a violation of fair housing. Does anybody have any questions so far? Alright, so record keeping. Making sure that we're abiding by fair housing laws also requires us to keep excellent records. Every call, every walk-in, every email inquiry regarding your community needs to be logged and recorded on a guest card. Failing to record a walk-in from someone from a protected class when everyone else has been recorded, that can be construed as a discrimination and a fair housing violation. On the flip side, not recording anybody else and then only recording the person that walks in the door from, well, quite frankly, everyone's in a protected class in one form or another. But recording a guest card from one person on a protected class, that can be construed as a violation as well because you didn't do it for anybody else. What is recorded on our guest cards and traffic logs is also important to avoid making a fair housing violation. You don't want to make any notes that could be construed as a violation if our records were subpoenaed in a court hearing. For example, you don't want to write pregnant woman with 2 kids seeking 2-bedroom apartment for family on a guest card. Older man with gray hair and a cane seeking 1-bedroom apartment on first floor. You don't want to say things like that because if our records were subpoenaed and we declined both those residents, they could say that they were declined because they were pregnant, which would be familial status, or old with a cane, a possible disability. Does that make sense to everybody? Yep. All of our guest cards, past resident lease files, rejected and canceled applicant files need to be kept for a minimum of 7 years. The reason being is our records can be subpoenaed for a fair housing court hearing up to 7 years. So we need to make sure that we keep them all organized and in a structured manner. At the end of every year, I will host a an end-of-year archive class, and it's just a brief 10-15-minute class. They'll let you know how to box everything up and make sure it's organized, remind you what you can and cannot throw away, and let you know how to store things to make sure that we're keeping things consistently. At the end of that 7 years, for example, if you are on a property and you found old files from 2001, 2002, 2003, feel free to have them shredded. Do not simply throw them away because our files often contain personal information about our residents or past residents, and you don't want to be simply throwing away people's social security numbers, bank account information, birth dates, so on and so forth. There are a lot of shredder companies that'll drop off a huge dumpster. You can put a bunch of stuff in it and they'll come pick it up and they'll shred the whole thing for $50 or something like that. So if you do have a bunch of stuff that you can get rid of, make sure you're doing it the appropriate way and having things shredded. If it's a lot of stuff, by all means do not sit there and shred each individual paper through your office shredder until you kill it and have to buy a new one, and kill it and have to buy a new one. Those are used for routine things throughout the office, not a big mass disposal. Do some research and find out about local shredding companies in your area. They're usually really inexpensive. For rejected applications, safe rent score information needs to be printed out and then attached to the application and guest card. You can take a red highlighter and note, or pink highlighter, note decline credit, decline background. You don't want to make any more notes other than that. And then that gets filed away wherever you keep your rejected or canceled applicant file. I usually do that by alphabetical order. Keep an A, B, C, D, E, F, G file folder just for canceled or rejected applicants. And then at the end of the year, I'll archive those up, box them up, put them wherever we store stuff, and then keep them for 7 years. Permit rules. As landlords, we have to have rules. It's appropriate for us to make sure that we set a set of house rules, provided that when we enforce the rules, it's consistent and applicable to all of our residents. For example, we need to stay away from rules stating that children should them out, roughhouse, or play in the hallways, as it can be construed as discriminatory against children. A more appropriate way to say the same thing was that the residents and their guests shall not roughhouse, play, or loiter in the hallways. Doesn't exclude any party, and quite frankly, whether you're 14 or you're 19, I don't want you roughhousing in the hallway. You could get hurt. You could get hurt, you could disturb other people, and 19-year-old residents can just be just as annoying and fun as 14-year-old residents. But you want to make sure that your rules are consistent. Check your pool rules as well. They need to be carefully reviewed because they can say the same thing. Children shall not run or roughhouse in the pool area. So make sure that they're reviewed carefully as well. We can say that children under such an age need to be escorted by another adult resident. That's perfectly fine, and quite frankly, that's usually mandatory by your state or some sort of local law that tells you about rules in public pools and so on and so forth. Evictions. We don't want to let fear of a fair housing repercussion intimidate us from processing a lawful eviction. If a resident is violating the provisions in their lease, it's our job to follow through with due process. There are two questions you need to ask. Have they violated the lease? And have you or would you evict someone else for the same reason? If you answered yes to both those questions, then obviously an eviction is warranted. When preparing to evict someone, make sure you have proper documentation of warning letters, eviction notices, written complaints by third parties, any and all police reports, and if photographs are applicable, those as well. Your resident file documentation needs to be consistent from resident to resident, and your documentation must show support of a legitimate reason for evicting a resident, and that it's unrelated to any fair housing discrimination. For example, I had property here in Fort Wayne that had a 13-year-old that was being destructive on the property. He lit the laundry room on fire. He was verbally threatening another resident's child. He was suspended from school at one point, but would still loiter around the bus stop to harass other kids on the property. There were several police reports filed. I had several complaints from other residents. I had to make sure I had that all documented so that I wasn't just saying, I'm evicting this punk kid. There were legitimate reasons why him and his family needed to go. He was causing destructions to property, to other residents. He was a threat. But I had to make sure that I had that all documented. Does anybody have any questions so far? No? All right. So next, fair housing can affect your advertising. You need to make sure that advertising is carefully worded, prepared carefully, so it can't be construed as a fair housing violation. You need to make sure that you are portraying facts about your community and not indications of what you're looking for in the perfect resident. Advertising shouldn't make claims like great for singles or perfect for the elderly, as you're clearly targeting specific types of people. You also need to make sure that you avoid using words like safe or exclusive for a couple reasons. Number one, if you advertise your property as safe and someone gets hurt or gets robbed or something bad happens on your property, they might try to sue you for lost my train of thought there. False advertising. There we go. And for another, it can hint that you may not rent to certain people. So you don't want to use the word safe or exclusive because you can open yourself up to problems in that case. Photographs and advertising also needs to be careful not to depict only certain races or other demographics. It's usually best to completely avoid having people in photographs of your apartments and community altogether. For example, photographs depicting only young families can be seen as discriminating against elderly or the handicapped. All advertisements, any flyers that go out, any brochures, anything that we have drawn up, needs to make sure that we use the Fair Housing logo, which looks like this. So I'll give you a funny story about Fair Housing and a property that I used to work at. I had a prospective resident call, and he was inquiring about an apartment. And I walked him through the leasing call, told him about our apartments, the pricing, our amenities, why it was such a great place to live. And he asked me how close the property was to a bus stop. And unfortunately, the property was over a mile away for a bus stop. And so it wasn't really convenient for public transportation. He followed back. Oh my goodness. I'm having like 4 different phone numbers call in on me at the same time. It keeps interrupting my train of thought. So, he's telling me, he followed up the question about the bus stop with informing me that his wife was in a wheelchair, and they needed to make sure that they were close to public transportation. I did inform him that the city of Fort Wayne does have special public transit just for handicapped residents or people that have accessibility issues. However, our apartments weren't handicap accessible. You either had to go down 7 stairs or up 7 stairs to access any of our apartments. There were no patio doors on the property that would be able to convert it and make it accessible. Just due to the age of the property, it wasn't built with ADA requirements, so it didn't meet current ADA requirements. And I tried to explain that to him, and he started screaming at me that I was in violation of fair housing and that he was suing me. And when he hung up the phone, he was calling Glazer Ned's attorney for injured people. And I tried to reiterate the age of the property, and I got hung up in this sentence, but it was hilarious at the time. But obviously you can't do much about your property if it's not constructed to meet current ADA requirements. There are certain things before we get into reasonable accommodations and modifications that you can and cannot do, but in the case of this instance, there was no way to make the apartment handicap accessible without doing a major structural change to the apartment community. You'd have to excavate, break into the concrete wall, create a ramp downstairs to get to the apartment. It wasn't even possible to put a lift because the hallways themselves were narrow enough that they wouldn't have room to have regular stair access along with the lift access, and it was just not possible, but it's kind of a funny story. Anyway, reasonable accommodations, there are differences and pay special attention between reasonable accommodations and modifications, because after we get off the training, there is going to be a quiz that's going to go out, and this is probably the #1 question that people miss when I hold this class. So pay attention to the difference between accommodations and modifications. So an accommodation is when a resident requests that an exception be made to a rule or a policy that accommodates a resident with a disability. So it's someone requesting a change to a rule or a policy. For an example, a community that does not allow pets. A resident requests that her seizure dog be allowed to stay with her as it detects seizures before they happen and it allows her to get to a safe location. This would be a request for a reasonable accommodation as it's a request for a service animal and it's not considered a pet. In a similar situation, for communities that do allow pets but charge fees or pet rents, you would not be allowed to charge a fee or impose additional rent, as service animals are not considered pets, but an extension of the person themselves. You also want to be careful that you don't offer an accommodation before it's requested, because this can be construed as an act of discrimination. For example, a blind man is requesting information regarding your apartment community. You assume that he needs a seeing eye dog, and you inform him before he asks that we'd be willing to accommodate him. He can take this as insulting and it will be viewed as discrimination. So they have to ask for an accommodation before we are allowed to accommodate them, for lack of a better word. All requests for reasonable accommodations must be approved by your regional manager and documented in the lease file. So, reasonable accommodations are a request for an adjustment to a rule. A reasonable modification is a request from the resident to make a structural change to their living area or apartment community in some way to accommodate them for a disability. So, a reasonable accommodation is to a rule. A modification is something that you have to physically change in the apartment. It's a construction. For example, a resident requests handicap bars be installed in their bathroom. That would be a request for a reasonable modification. Also make sure that you note that any and all modifications regarding equipment installation must be completed by an outside contractor. We don't want our maintenance to do them in-house, even though something such as handicap bars installation might seem very, very simple. We want to make sure that they are properly installed, and quite frankly, that the risk, if they're not properly installed, is put on the contractor and not on our shoulders if it's done incorrectly. For example, for the handicap bars, if they're put in and they're not put in directly on a stud, they're just put into the tile, and a resident slips and they fall and they grab a hold of that handicap bar and the handicap bar rips out of the wall. We want that to be on the contractor's head and not ours. So make sure that any reasonable modifications are completed by an outside contractor. Also, in market rate housing, reasonable modifications may be paid for by the resident, and it must be removed upon them vacating the apartment home unless the removal would cause significant damage to the unit and it causes no functional restrictions to the apartment. For example, the handicap bars would not cause a functional restriction, so we would probably leave them in place. Taking them out will put holes in the tile. You'd have to replace the tile, or if it was a tuck surround, replace the whole tuck surround. And leaving them there doesn't make the bathroom any less functional for somebody else. If a reasonable modification is something that is required by law, it may be determined that it's the landlord's financial responsibility. Again, anytime we're dealing with some kind of request, whether it be an accommodation or modification, you need to discuss it with your regional manager and figure out the best course of action. In government housing, reasonable modifications might be the landlord's financial responsibility as well. So if you have a property that's completely Section 8, typically it's their responsibility to make those changes. And again, consult your regional manager before making a change. Does anybody have any questions so far? No? Alright. If you have a rental property that has 4 or less units, and one of those units is occupied by the owner, fair housing laws don't apply. They can rent to anybody and everyone that they feel. If they only want to rent to old people with one leg, they are more than welcome to rent to only old people with one leg. It's their home, it's 1 unit or less. They don't have to apply by fair housing law. On the same kind of sphere, if you do single-family home rentals, unless you own more than 3 single-family homes, or if you use a licensed real estate professional, you don't have to abide by fair housing. There's also the Housing for Older Persons Act, and that applies that the familial status protected class does not apply to housing specifically for those 55 and older. So the Housing for Older Persons Act excludes the familial status protected class. All other protected classes they do have to follow, but the familial status one they do not, because they do not have to house anyone that's under 55 at those kind of homes. Religious organizations or private clubs can also be excluded from following fair housing. for example, a sorority or fraternity house that they rent to people within their organization, that's considered a private club, and they don't have to follow fair housing. So penalties for violating fair housing laws. Civil fines and penalties from $1,000 up to $50,000 can occur per occurrence. In addition to civil fines, punitive damages can be awarded depending on the severity of the discrimination as well. And then criminal charges can be brought and pursued, which have penalties including additional fines and possible jail time. And then if you're licensed, you have a real estate license and you violate fair housing, you can also have your license revoked. Who is responsible for following fair housing? Any individual involved in a rental or housing real estate transaction is responsible for following fair housing laws. This includes our owners, managers, district managers, leasing agents, real estate agents, mortgage lenders, brokers, etc. We had a property in Ohio at one point that the owners asked us if we could put the refugees in one section of the apartment community and lease the rest of the apartment community to quote-unquote normal people. We had to inform the owners that that was a violation of fair housing and not something that we could do. So they are responsible for following fair housing as well. How to make sure you stay in compliance. You want to avoid speaking about specific demographics or specific types of people. Earlier we used the example of a prospective resident asking you what type of people live there. Always respond, we rent to anyone who meets the qualifying criteria. You want to make sure that we're maintaining accurate records on everyone who expresses an interest in your community. We want to follow the marketing and advertising guidelines that we discussed earlier to avoid discrimination in advertising. And if you strive to treat everyone the same in all property management business, and you follow all established rules and guidelines for everyone, you're going to discriminate against no one. So what's new? The HUD, Department of Housing and Urban Development, has developed a housing discrimination mobile application for iPhone and iPad users, which provides the public a quick and easy way to file housing discrimination complaints. What's that mean? No one no longer has to go down to their local Housing and Urban Development Department and fill out a form in triplicate and wait in line at a government office to file a complaint. It's quick, it's easy, and it just makes it easier to access a discrimination complaint for anybody that feels they're being discriminated against. The apartment world lately has also been delving into requiring pets to be declawed and or debarked. If this is a requirement for pets, which, as a side note, is illegal in the state of California, we can't require that for service animals. For example, we talked about seizure dogs earlier. If the way of notifying their owner is by barking to let them know that they have a seizure that's coming, we can't ask for them to be debarked. Again, the service animal is an extension of the person. It's not a pet, so we can't hold them to the same rules as a pet. You can still require someone who has a service animal to clean up after their pet. That's a typo. Side note, there are vendors that allow residents to register their pets and have DNA registered for about $30 a pet. And you can then have any messes tested to match a specific pet and see if the pet is registered. Not sure if that's something that you'd be interested in your community or talking to your regional manager about. But if you have a mess problem at your property due to pets, it might be something worth considering. Another bit of new information, or new in fair housing, multiple chemical sensitivity is now considered a disability and it falls under the Fair Housing Act. This means that some people are impacted by a low level of chemicals that doesn't normally affect regular people. And this may mean we have to change what we paint with in a particular apartment, our extermination chemicals, and we may have to address issues with neighbors. MCX does not include regular allergies. So people that have pollen allergies or bee allergies, or what have you, that's not included under multiple chemical sensitivity. That is definitely a disease that has to be named by their doctor, that they are impacted by those low level of chemicals.